आगाज करेंगे। सबसे पहले अहम खबर आपको दें कि दुनिया की बड़ी अदालत में बड़े दहशतगर्द के केस की समाअत जारी है। आलमी अदालत इंसाफ में पाकिस्तान का भरपूर मौक़िफ़ सामने आ गया। खाविर कुरैशी ने मौक़िफ़ इख्तियार किया कि कुलभूषण यादव दहशतगर्द कमांडर है और भारत के तमाम झूठ इस फोरम पर बेनकाब कर रहा हूँ।
कई भारतीय अखबारात ने कुलभूषण को जासूस माना। भारत सबूत फराहम करने में मुकम्मल नाकाम रहा है। दुनिया की अहम तरीन और बड़ी अदालत इंटरनेशनल कोर्ट ऑफ जस्टिस, जहां पर पाकिस्तान ने कुलभूषण यादव के खिलाफ पाकिस्तान का मौक़िफ़ भरपूर अंदाज में पेश किया है और पाकिस्तान की जानिब से वकील खाविर कुरैशी ने मौक़िफ़ इख्तियार किया कि कुलभूषण यादव दहशतगर्द कमांडर है। भारत के तमाम झूठ इस फोरम पर बेनकाब कर रहा हूँ।
Guilty of egregious illegal conduct in providing Commander Jadhav with an authentic passport and false identity and dispatching him to carry out acts of espionage and terrorism in Pakistan in contravention of the Charter of the United Nations. The Attorney General gave the court an insight. And of course, it's all too often the case that complaints and counter-complaints, allegations and counter-allegations. Here, perhaps for the first time, we have a court which is presented with clear, compelling, uncontradicted evidence of the turpitude of a state abusing the facility of provision to provide one of its agents of destruction and terror with a facility to be able to wreak havoc in Pakistan. Havoc that, thanks to the sterling work of the Pakistani security services, he was prevented from continuing. Havoc which must have consequences, not just for India, but for Commander Jadhav. The idea that he can be immune in the way that India suggests it is immune for its actions is obnoxious, I'm sorry to say. And we say, as a consequence of all the evidence that's before the court, the burden of proof shifted to India in December 2017. After all, India asked for a further round of pleadings to fully rebut the facts and the law. And what did it do? It didn't. The burden of proof shifted to explain the passport issue and explain India's conduct. It just wasn't acceptable to avoid doing that. The second aspect of India's conduct, which is unsavory and which I'm forced to bring before this court, is the report of the military experts and India's doctoring of it. India doesn't like the truth, I'm sorry to say, and I'm not going to varnish it, because the truth has to be heard. Yesterday, we heard Mr. Salve's mealy-mouthed explanation for doctoring the experts' report. And yesterday, the experts had, by way of a supplemental report, sought to make it absolutely clear what they intended in their report, lest anybody who doesn't understand the English language in the way that it's meant to be understood was under a false impression. And India tried to block that. It wasn't an unabashed attempt to lead further evidence. It was to address misrepresentations, but of course that's not what India wanted. What was impermissible was not allowing the experts to come before the court and say, unlike Humpty Dumpty, we used plain English. We didn't give India a license to add or delete words. India didn't want you to hear that, honourable members of this court. But I'm telling you now. The military experts, the distortions, the shocking distortions. The first one is the typographical error that my learned friend says entered into paragraph 154. But he couldn't stop himself, because yesterday, paragraph 222 of the transcript, he said, in paragraph 3D of the report, the experts state their conclusion that manifest failings can be remedied by judicial review. India relies on this statement as an acknowledgement that there are manifest failings. I don't see how, given that they used the word potential. But there you have it. We obviously have been using different languages and different dictionaries in different parts of the world. It does so in paragraph 19 of the reply. Pakistan does not.
इंटरनेशनल कोर्ट ऑफ जस्टिस से ये बराह रास्त मनाजिर आपको दिखा रहे हैं GNN की स्क्रीन पर, जहां आप देख सकते हैं कि खाविर कुरैशी QC जो कि पाकिस्तान की जानिब से कुलभूषण यादव के खिलाफ अपने दलाइल पेश कर रहे हैं, क्योंकि गुज़श्ता रोज़ हमने देखा था कि भारत ने अपने दलाइल मुकम्मल किए थे और आज पाकिस्तान की जानिब से दलाइल दिए जा रहे हैं, जिसके बाद इस मामले पर जिरह की जाएगी।
Deleting the word often was the second distortion. And then wanting to pretend that the experts, as objective, independent bystanders, with their expertise and credibility, were not trying to help the court by referring to the fact that courts which tried terrorism offences both in India and Pakistan had both been subject to general criticisms. They gloss over the reference to India and Pakistan and create the irresistible impression that the experts were only referring to India. Now, if one mistake had been made, one could understand it's perhaps carelessness, incompetence. If two, troubling. Three, deliberate. Even worse. As the court knows, we have repeatedly written to India to ask India to correct. In June of last year, before we were finalizing our rejoinder, we asked India to correct to check the contents of the rejoinder, and we were brushed aside when the rejoinder was filed. Subsequent to that, India could have corrected. We were brushed aside, told, take it up with the court. We took it up with the court on the 19th of January of this year, and what happened? India maintained its position. Then I, as a matter of professional courtesy, drew it to the attention of my friend Mr. Salve on the 7th of February, because some of us still believe in professional courtesy, some of us believe in professionalism. I'm sorry to say I never received a reply from Mr. Salve. I pointed out 14th of February would be an opportune date to provide me with a response so that we could take stock. So to say that the experts have been deployed before this court late, as India has done in its letter of yesterday, fails to prepare the court and provide the court with a full picture. Unsurprisingly, we were trying to give India every single opportunity to correct, to clarify, to apologize. And it's only at the last moment that we wanted the court to be made aware exactly of what the experts had said, and that is why the experts were keen to ensure that there was no misunderstanding and to file a supplemental report. Each and every opportunity India was given, arrogantly, it dismissed. Well, you can't dismiss the truth. It's here now. And each and every one of those opportunities just adds to the edifice of deliberate conduct. Because if you're given 4 opportunities to correct the position and you don't, it's difficult to conclude other than you're being cavalier, you're being arrogant, but you're also being very insulting. And that won't work. There may be some courts in this world where it's possible to get away with a license of this nature, but this court is not a court where any litigant, let alone a state, or any advocate can be allowed to play fast and loose with the truth. And it's important for this court, even if this is the first time ever in the court's history, to identify what the red lines are for conduct. Sadly, we're living in a world in which the rule of law is coming under increasing threat. And it's important for this court, as it has done historically throughout its existence, to inform the world where the lines are and not to allow them to be erased or blurred by states that believe that alternative facts, fiction, fantasy, fallacy, are the order of the day. And then we move on to the second category of misleading. It wasn't enough to doctor the military experts' report. India had to then try and disavow its own handiwork. The 2008 agreement on consular access. India's reply said, this has no bearing on the present dispute. I remind myself, the title was Agreement on Consular Access. But now it says it does have meaning. It does supplement and amplify the understanding of the parties vis-à-vis the Vienna Convention in some ways, but conveniently not in this case. Why? And this is where yet further distortion comes in. because what India does is totally misreads deliberately the terms of the convention, the bilateral agreement. Pakistan's not relying on Article 4 or 5, it's referring to standalone provision, Article.
आलमी अदालत इंसाफ में इस वक्त बैरिस्टर खावर कुरैशी पाकिस्तान की जानिब से दलाइल दे रहे हैं। उन्होंने कई बुनियादी सवालात उठाए हैं जिनका जवाब अब तक नहीं मिला।
Have a meaning. This is not a lesson in punctuation. This is a lesson in accuracy. Article 6 says the following. In the case of arrest, detention or sentence made on political or security grounds, each side may examine the case on its merits. That's pretty clear language. What does India do? In its memorial, paragraph 92. The 2008 agreement was entered into for furthering the objective of humane treatment of nationals of either country, arrested, detained or imprisoned in the other country, and by which the two signatory states, India and Pakistan, agreed to certain measures. No qualms with that. These included the release and repatriation of persons within 1 month of confirmation of their national status and completion of sentence. No qualms with that. The agreement recognized that in case of arrest, detention or sentence made on political or security grounds, each side may examine the case on its merits. Absolutely right. That's Article 6. But then what happens? The text, the mischievous comma, and the addition of the words "and that," what I describe politely as India's creative addition, others may say deceit. In special cases which call for or require compassion and humanitarian considerations, each side may exercise its discretion, subject to the laws and regulations, to allow early release and repatriation of prisoners. India does not seek early release or repatriation of Jadhav, as contemplated by the 2008 agreement. What utter nonsense. By simply, I say simply, adding a comma and the words "and that." And no doubt Mr. Salve eventually, when pushed, will tell us that was yet another typo. It's a simple fact that the 2008 agreement was negotiated over a period of 3 years. Indeed, it expressly sought to replace an earlier agreement, operating since 1982, no less. Article 3 of that agreement, which the Article 6 sought to replace, was much more detailed. Each government shall give consular access on a reciprocal basis to nationals of one country under arrest, detention or imprisonment in the other country, provided they're not apprehended for political or security reasons offences. Requests for such access and the terms thereof shall be considered on the merits of each case by the government arresting the person or holding the detainees prisoners, and the decision on such request shall be conveyed to the other government within 4 weeks from the date of receipt of the request. It's exactly the same language, consideration on the merits, political security reasons, offences. Somehow, unfortunately, when it comes to this case, India's answer is, but Pakistan never referred to it. Well, you did, as I'll show shortly. And when did you refer to the Vienna Convention on Consular Relations, as my little friend reminded us yesterday, in your regular missives about consular access? Did you invoke the Vienna Convention on Consular Relations? Was it necessary? You're saying it's an agreement between the parties. So was it necessary to refer to it? Was it equally necessary to refer to this 2008 agreement? And we'll come to the 2000 agreement subsequently. And the third category of misleading, which I have to say I am much more disappointed about, because I would have wanted Mr. J.P. Singh to be available for this court. He submitted what he described as a 7-page report dated 26 December in the aftermath of the visit to Commander Jadhav of his wife and mother. Now, if it's being suggested that Commander Jadhav's visit was evidence of impropriety on the part of Pakistan, we're very happy to share the entire video, unedited, of the interaction between Commander Jadhav and his wife, with J.P. Singh looking on to ensure that matters were dealt with properly. And the video will show that Commander Jadhav's mother commented on his excellent health. We referred to the report as being materially inaccurate, and we asked Mr. Singh be tendered for cross-examination. India refused and said we should take it up with the court. We asked, by note verbal, 5th of June, for India to check the accuracy of the contents of the reply. And again, we were told, in essence, as is characteristic of India. This is inappropriate, irrelevant, by letter dated 27th of June 2018. So much for wanting to help. Sadly, even in this day and age, sadly, even a handshake seems to be misunderstood. On one side, it's a sign of respect. On the other side, it's a sign of shame, decorum. That's all we're asking for. So we asked the court on the 18th of January for Mr. Singh to be available for cross-examination. And the reply was a model of evasion. Well, he didn't give a witness statement. He gave a report. And then what happened? Oh, by the way, he's corrected his report. The date wasn't the 26th of December. It was the 5th of January. And this is the
QC खबर कुरैशी की जानिब से इस वक्त द हेग में आलमी अदालत इंसाफ में मुकदमा पेश किया जा रहा है पाकिस्तान की जानिब से और ये मुकदमा है कुलभूषण यादव के खिलाफ.
Why, one asks, when we were raising this with you in June of 2018, when you had notice from us that there may be issues about inaccuracy, why is it that Mr. Singh is writing this letter in August 2018? Was it the monsoon heat that got to him, that made him remember the date of the letter? Because what he says is, I know it's dated the 26th of December, eligibility is not quite right for whatever reason, happy to see the original, but you should read it as 5th of January 2018, sent to Dr. Mittal. Now, I'm sorry that he's not here, because this letter can be easily demonstrated to be a concoction, to use India's words, a manufactured. Melodrama is added to this letter by the use of the word secret at the top right-hand side. Bizarre that a letter that is supposed to be secret finds its way as an annex to a reply to a plea to a case before the International Court and is now being seen by the world at large. We will see at the bottom that J.P. Singh arrived in Delhi at 3:45. It's dated 26th of December 2017. It's 7 pages. And he says at the bottom he signed it in New Delhi. Well, actually, he didn't. He says himself he didn't. So the date's wrong. The date of the letter, when he signed it, is wrong. Where he signed it is wrong, because on the 28th of December he went back to Pakistan, where he's the Deputy High Commissioner. And what else was there in this letter that is objectionable? It's written to Dr. Mittal, and I'm reminded that he's sitting next to me. Of course, he's the agent for India. If anybody knows about Indian culture, it's Dr. Mittal. And what does he say to him? While the government of Pakistan had assured a security check with full dignity, the Pakistani security official removed all the ornaments and bangles, including Mangal Sutra and Bindi, which are of immense religious sensitivity in Indian society and a symbol of a married woman. Did Dr. Mittal really need to be told that? Did he really need to be told that? Please. You may fool yourselves, but you don't fool the rest of the world. And then what does he say? The appearance of Mr. Kulbhushan Jadhav. While I could not hear the conversation of Jadhav and family members because of 2 glass partitions, the physical appearance, gestures and body language indicated the following. His face was looking...
Mr. Qureshi, the interpreters are having a lot of difficulty to follow you.
I apologize.
So if you can please slow down for their sake.
I can only apologize. I'm conscious and anxious to ensure that the material is... We have a time limit. I want to stick to the time limit. I'm not one for elongating time limits, so I apologize for going through this at my normal canter speed. I shall refrain. I'll move into walking trot, shall I? Yadav's face was looking puffy and swollen. He was very hyperactive. Seemed as if he was not in his senses, was under the influence of something. Shorthand. He'd been tortured. He'd been drugged. This is an independent medical expert, no less, Dr. Nilsson, a German national, not a Pakistani national, based in Dubai at the Saudi German hospital, a consultant who produced a 14-page medical report, independent medical examination on the 22nd of December. concluding that Commander Jadhav was in excellent healthy condition. 3 days later, we're told he was looking puffy and swollen. He's not in his senses. Now, I have to make the following observation. It means this, that up until the doctor saw him, Commander Jadhav was healthy, and in the interim, he was tortured and sedated. Now, I don't mean this in jest, but was that necessary for him to see his mother and his wife? Is that the reason? It just illustrates the absurdity of the proposition. And then paragraph 15. KJ's video released by Pakistan side after the meeting. The court hasn't seen this, but I may as well tell everybody what the video says. It's Commander Jadhav, untutored, unprompted, exasperated at the fact that JP Singh was shouting at his mother and wife. This video was released on the 4th of January 2018, not a few days after the meeting. So you see the entire narrative of JP Singh breaks down, because it wasn't a few days after. So much for truth and accuracy. I do wish JP Singh well.
बैरिस्टर खावर कुरैशी की जानिब से इस वक्त दलाइल दिए जा रहे हैं। कल भारतीय वकला की जानिब से दलाइल दिए गए थे, जिसका जवाब आज बैरिस्टर खावर कुरैशी दलाइल की सूरत में दे रहे हैं।
Third point, at no material time, even now, has India furnished any evidence that Commander Jadhav is an Indian national, despite repeated requests. The gateway point that I mentioned at the outset. Is this a convenient moment?
It's a moment for a break, and therefore the court will observe a 15-minute break. The meeting is adjourned.
आलमी अदालत इंसाफ में 15 मिनट की ब्रेक हुई है, और इससे पहले जो जज साहिबान यहाँ पर बैठे थे उनकी जानिब से ये दरख्वास्त की गई कि खावर कुरैशी साहब थोड़ा आहिस्ता बोलें, क्योंकि जो मुतरज्जिम हैं उनको मुश्किल हो रही है तर्जुमा करने में। तो खावर कुरैशी ने कुछ स्पीड हल्की की, लेकिन उन्होंने इस बात का भी इंदिया दिया कि वक्त की कमी के बायस वो तेज़ बात कर रहे हैं, लेकिन वो भरपूर अंदाज में पाकिस्तान का मुकदमा दलाइल की सूरत में पेश कर रहे हैं। बहुत अहम पॉइंट्स उनकी जानिब से आज उठाए गए हैं, और उन्होंने ये कहा है कि जो रेड लाइंस हैं उनको ये पहला मौका है कि डिफ़ाइन किया जा रहा है और पूरी दुनिया को बताया जाए कि हुदूद क्या होती हैं। खून बहाने की किसी को इजाज़त नहीं दी जाएगी। उन्होंने भारत को मुखातिब करते हुए कहा कि आप ख़ुद को तो बेवकूफ़ बना सकते हैं, लेकिन आप दुनिया को, पूरी दुनिया को बेवकूफ़ नहीं बना सकते। उनकी जानिब से दलाइल का ये सिलसिला जारी था, और 15 मिनट की ब्रेक हुई है क्योंकि आज पाकिस्तान की जानिब से ये दलाइल दिए जाएंगे। गुज़श्ता रोज़ हमने देखा था कि जो भारतीय वकील हैं हरीश साल्वे, उनकी जानिब से दलाइल दिए गए थे, जिसका जवाब आज QC खावर कुरैशी की जानिब से दिया जा रहा है।
बिल्कुल, और जिस वक्त सलमान दलाइल दिए जा रहे थे बैरिस्टर खावर कुरैशी की जानिब से, तो आप देख सकते हैं कि भारतीय हाई कमिश्नर अपना सर पकड़कर बैठे हुए हैं और भरपूर उनकी जानिब से जवाब दिया गया है। कई सवाल उठाए गए हैं कि भारत इस मामले को आलमी अदालत इंसाफ में लेकर आया, और अब पाकिस्तान की जानिब से जो सवाल उठाए जा रहे हैं उसका जवाब देने से तहरीरी तौर पर भारत इनकार भी कर चुका है। कौंसल रसाई का उन्होंने जिक्र किया कि जब भारत ने वाज़े ही नहीं किया कि इनकी शहरियत क्या है, क्या वो कुलभूषण यादव है या फिर हुसैन मुबारक पटेल हैं, तो फिर कौंसल रसाई किस तरह से दी जाती है। उन्होंने कहा कि इस मामले पर भारतीय मौक़िफ़ जो अब तक अपनाया गया है वो मज़े का खेज़ है। अगर कुलभूषण को ईरान से अगवा किया गया था तो भारत ने अभी तक ईरान से राब्ता क्यों नहीं किया है। अगर कुलभूषण यादव रिटायर्ड कमांडर है तो उसकी रिटायरमेंट का सबूत अब तक पेश क्यों नहीं किया गया है।
इसी पर हम बात करेंगे, और अब तक की जो कार्रवाई हुई है इस पर हम तज्ज़िया हासिल करेंगे। डॉक्टर प्रोफेसर हसन अस्करी रिजवी साहब हमारे साथ मौजूद हैं। डॉक्टर साहब फरमाइएगा, जो पाकिस्तान की जानिब से सवालात उठाए जा रहे हैं, बुनियादी सवालात हैं, आपको क्या लगता है कि भारत इसका जवाब नहीं दे पा रहा, इसका कितना नुकसान हो सकता है उसको इस केस में?
देखिए, बुनियादी सवाल तो जो भारत ही ने उठाया था इस केस के अंदर कि उसको ज़बरदस्ती ईरान से अगवा करके पाकिस्तान लाया गया, मुकदमा चलाया गया वगैरह वगैरह, अब उन्हें इस सारे मामले के सबूत मुहैया करने हैं कि वो अगवा हुआ, फिर ये कि वो जासूस नहीं है, वो एक इंडिविजुअल था। ये बातों इंडिया ने अपना जवाब दिया, पाकिस्तान ने आज अपना जो है इशू रेज कर दिया है। अब देखना ये है कि कोर्ट उन एविडेंस को जज करके किस नतीजे पर पहुंचती है, तो ये वक्त बताएगा। लेकिन इस वक्त पाकिस्तान के आर्गूमेंट काफी स्ट्रांग हमें नजर आते हैं।
ठीक, बहुत बहुत शुक्रिया प्रोफेसर हसन अस्करी रिजवी, हमें अपने तज्जिए से आगाह कर रहे थे।
इस बारे में कुछ मजीद बात करेंगे, आपको मजीद बताएंगे, लेकिन यहाँ